Forms of ownership. Concurrent ownership. Frequently, real estate is owned by more than one owner. This is referred to as concurrent ownership, and it can take different forms, including tenancy in common and joint tenancy with rights of survivorship. Although tenancy in common and joint tenancy sound similar to one another, they have some important differences. You should pay close attention in order to understand the distinctions between the different ways multiple people can own real estate together, because it affects a number of things, ranging from what happens to real estate when an owner dies, to what happens when real estate owned by more than one party is sold. Tenancy in common. When two or more parties own a piece of real estate as tenants in common, each owner owns a divided piece of the overall parcel of real estate. You can imagine a cake, which in this case it will be the property. Each owner will get a piece of cake. However, the pieces are not necessarily equal, as some owners may own a larger portion of the property than the others. This means that when one owner dies, their share does not automatically pass to the other owners. Instead, the deceased owner's shares will pass according to their will. Or in case there is no will, then it will pass according to state law. In states that allow owners of real estate to create transfer on death deeds, or beneficiary deeds, a tenant in common can use those tools to pass their section of the real estate to one or more named beneficiaries, outside of probate court, at their death. Tenancy in common is frequently the way property is held when siblings inherited their parents' property, or when business partners purchase a piece of real estate together. When multiple people own property as tenants in common, each owner may have a different percentage of ownership. That is to say, they do not need to be equal property owners. Let's look at an example of tenancy in common. John, a widower, who owned a cabin in his name alone, died. His will left all of his assets, including his real estate, to his 5 children. When the cabin property passes through probate court, the deed transferring title lists each child's name as a grantee, specifying that each owns an undivided 1/5 interest in the property. So, the property is now owned by the 5 children equally. However, if one of those children died, leaving their property to her 4 adult children, ownership of the property becomes even more fractionalized. Each of John's surviving children still owns their undivided 1/5 interest. The 4 adult grandchildren, the children of John's deceased daughter, now own 1/4 of 1/5, or a 1/20th share of the real estate. Joint tenancy. Joint tenancy is another way more than one party can own real estate together. When parties own real estate as joint tenants, they have the equal, undivided right to sell, mortgage, transfer, or encumber their property. No one owner has a greater share than another. If we come back to our cake analogy, in a joint tenancy, every owner will get an equal piece of the cake. When property is owned in joint tenancy, the deed or title should reflect this. When property is owned jointly, there are 4 unities of ownership: unity of possession, unity of interest, unity of time, and unity of title. Simply put, this means that all of the owners have equal rights and responsibilities for the property. Property held in joint tenancy has rights of survivorship. This means that when one joint owner dies, their share of the property passes by law to the other joint owner or owners, rather than passing through their will or other legal document. Joint tenancy with rights of survivorship is terminated when one owner dies. Also, it is terminated if the owners join together to sign and record a deed transferring ownership into someone else's name. That someone else could be the other joint owner or owners. Here's an example of joint tenancy that you might encounter when you're working as a real estate professional. Amy and Chris, a married couple, are buying their first home. They will own it as joint tenants with rights of survivorship, so if either one of them dies while owning the home, ownership will pass to the survivor of them, outside of any court proceedings. Let's assume Amy dies. Then her property share will automatically be transferred to Chris. Even if Amy and Chris have children, Amy's property share will go to Chris and not their children. Termination of co-ownership by partition. A partition, in real estate, refers to a court proceeding that officially severs co-ownership of the parcel of land or property. This may be necessary when there is a disagreement among the owners about how to use, maintain, or dispose of the real estate. Sometimes, when the parties cannot agree to voluntarily partition the real estate, the court will require the owners to sell the property and divide the proceeds. Tenancy by the entirety. In some states, there is another option for concurrent ownership. Tenancy by the entirety with rights of survivorship. Simply put, property owned by a married couple held as tenancy by the entirety means that both spouses have an equal and undivided interest in the real estate. Tenancy by the entirety functions much like joint tenancy with rights of survivorship for a married couple in those states. That means that when one spouse dies, the ownership of the real estate passes to the surviving spouse. Tenancy by the entirety is terminated when one spouse dies, or when both spouses join together to transfer ownership to another party. Neither spouse can sell or transfer ownership of the property without the other spouse's consent. Community property. There are 9 states today that have specific community property laws on their books, designed to protect both spouses in a marriage. These states are commonly referred to as community property states. Such states include Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin. Simply put, property owned by married people in any of those 9 states is considered property of both or either of the spouses. There are 2 common exceptions to the community property treatment. The first exception is when property was acquired specifically as a separate property by one of the spouses before the marriage, so it was owned before the marriage by just one of them. In that case, it can continue to be held as individual or separate property. The second exception is for real estate or other property that one spouse inherits or receives as a gift in their name alone after the marriage. In most cases, that property can also be treated as separate property, even in a community property state. With community property, each spouse has an equal right to any real estate the couple owns, where with joint tenancy, spouses own property together in an undivided fashion. With community property, essentially, each spouse owns 1/2 of the property. Neither spouse can sell or transfer ownership without the other spouse agreeing to the transfer. Let's look at an example that will make this concept more sense. Jill and Ken were married and owned their home together in California. Unfortunately, their marriage fell apart and they filed for divorce. Because California is a community property state, neither Jill nor Ken could dispose of their share of the property before or during the court proceeding without the other's consent. And again, Because the state of California is a community property state, odds are that the court will divide the real estate 50-50, meaning that both Jill and Ken will receive a 1/2 share. Although an attorney is best suited to advise clients on what form of ownership applies best to their case, you might be asked by buyers for some guidance on this issue. As a real estate agent, it is generally prudent to never give advice, and you should direct your clients to an attorney. Too many agents fall prey at confusing helping clients with giving them legal advice, which is a big no-no. So please do not advise your clients on what type of ownership will suit them best, even if they ask. You can politely recommend an attorney that they can speak with and emphasize the fact that you are there to provide them with guidance regarding the property.